Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Ilindra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to the reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of the immigrant community and for the benefit of US employers. The reddyesq.com site provides you with the latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the I-485 interfiling and Visa Bulletin updates on the Build Back Better bill. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Hello, Ms. Reddy. Before we get into the topic, do we have any latest immigration updates for this week?
Hi, Tony. It's a pleasure as usual being on the show. And yes, we do have some updates. I thought I'll start with, of course, the I-485 interfiling. That's a big hot topic of the day. Everybody is very anxious to hear about what USCIS has to say about I-485 interfiling. But we should start off with giving a quick update on the Visa Bulletin. So Visa Bulletin for February just came out. EB1 remains current for all countries. And for final action date, EB2 China advanced by 1 month and 11 days. EB3 China remains unchanged. EB2 India, and this is a big one, advanced by 5 months and 25 days. So it's now on January 1, 2030. EB3 India remains unchanged with a cutoff date of January 15, 2012. So the big news for final action dates is EB2 India moved by 5 months and 25 days, almost 6 months. And we've been seeing this continuous EB2 forward movement for quite a few months now. And that's why a lot of cases, I-485s are being refiled or being filed as duplicate because the downgrade from EB3 to EB2, what happened in October is EB3 was current and EB2 was not. So a lot of people who had EB2 I-140s downgraded to EB3 and filed their 485. So now they're doing the reverse. It's like a seesaw. And they're filing again from EB2 to EB3. And now seeing the influx of 485s, duplicate 485s being filed for EB2, USCIS has put out some I-485 interfiling reminders, but we'll talk about that later. EB3 remains, as I said, unchanged. So another big news for the Visa Bulletin is dates for filing continue to be used. So we can continue to use dates for filing in February as well. Again, EB2 China and EB3 China have not changed. EB2 India has advanced by 1 month and 25 days, so almost 2 months. Not as significant as the final action date, but there's some movement. EB3 India is unchanged. So a recap for dates of filing. Movement in EB2 India by almost 2 months, and everything else remains unchanged. I also wanted to give you an update on the Build Back Better bill, because this is related to the visa numbers. It's related to the 485 filings, because in this bill there are provisions to allow people to file 485s even though their visa number may not be available by paying a certain amount of fee. There are provisions to make the unused visa numbers available from previous years, so the number of visa numbers will increase. So this is important for our topic today. With reference to the Build Back Better bill, So basically what's happened is they've tried to include the immigration provisions in the budget bill, and they need the Senate parliamentarian to approve it, and she's rejected it already 3 times, Elizabeth McDonough. As a result of this rejection, now the Senate has to decide whether they want to go ahead despite the rejection, and they can, because this is only advisory in nature. So the advocacy groups and people like you who are waiting for their visa numbers are urging the Senate, the senators to proceed with the bill. This is a more politically risky strategy, but you should try to convince the Senate Democrats to disregard the chamber's advice and continue with the bill. Now, in order to do this, as per, if we want to follow the disregard policy, then 41 Democrat senators would have to vote to sustain the parliamentarian rejected language, to keep it in there. There are altogether 50 Democrats, and to pass the final bill, 50 Democrats would have to vote, and that's challenging because one Democrat from Virginia, Joe Manchin, has said that he wouldn't support the bill. And so they have to be able to convince all 50 Democrats to support the bill. Also, midterm elections are approaching, and Republicans have the chance to gain control of one or both chambers of Congress. So Democrats have a short window to pass all these sweeping immigration reforms that they're trying to pass. So now is the time for advocacy, and now is the time to urge them to, move forward with the bill. So that's the update for the visa numbers and also what's happening with the new legislation. Now, Tony, we can go to, the 485 interfiling information that we have.
Right. Yes, Ms. Reddy. So you wanted to particularly discuss the I-485 interfiling, as a whole process. Could you please explain to our viewers what interfiling here is?
Sure. So USCIS, so as I said, the situation is such that people have started filing duplicate 485s based on their EB2 approvals, because they have an I-140 for both EB2 and EB3, because they downgraded it and that doesn't affect their original EB2 petition. So instead of relying on interfiling, what they were doing is they were filing new 485 applications. And I was saying in a previous show that I had that why USCIS is not reminding people that there is an interfiling option and that they are actually actively looking into interfiling cases. So now they have, and the reason they're doing that is because a lot of people are filing duplicate 485s, and that will clog the system again, as they will have to process, 2 485s for each person. And as it is, they're not able to process the 1 485 also. Even if the dates are current, they're not able to process those cases on time. So the USCIS has made an announcement reminding us of the 485 interfiling. This is an old provision which has always been there, but I guess the community has not had much confidence in the process, because they were not sure if they asked for this interfiling that the USCIS would actually pay attention. So they have made an announcement that interfiling is still good, and they're still going to continue to look into it. Now, to go back, they've announced some new procedures for interfiling, but just before that, just to tell you what interfiling is. So if you have an I-140 for an EB3 and an EB2, and you wish to, your 485 was filed in an EB3 category, but you wish to now use your I-140 which you have in the EB2 category, because now, as you can see, EB2 is moving much faster than EB3, and you might be current for EB2. So if your EB2 is current and you filed under EB3, you can write a letter to USCIS and ask them to transfer the 485 to your other I-140, to the EB2 I-140, without having to file a new 485. So that's called transfer of underlying basis. That's how USCIS calls it, and we just call it 485, interfiling or I-140 interfiling, just to, keep it simpler. So as per their latest announcement, they have said that USCIS may, in its discretion, grant a transfer request, provided you have continuously maintained eligibility for adjustment of status, which means that you continue to have a 485 pending, and you continue to be eligible for a 485, and your adjustment of status application based on the original I-140 is still pending, which means your 485 has not been denied or has not been withdrawn, but it still continues to be pending. And you're eligible for the new immigrant category, which means the EB2 I-140 that you want to now interfile, it should still be available. It should not have been withdrawn, or some circumstances should not have changed which make you ineligible to use that EB2 I-140. And also, most important, a visa number should immediately be available. So simply because you have an EB2 I-140, you cannot ask for interfiling unless the visa number has now become current. Not for dates for filing, but final action date should be current for that EB2 I-140 in order for you to request interfiling. Now, the interfiling request should be done in writing, and you should give in that letter all the information relevant to the new I-140. You should ask specifically that the I-485 be adjudicated based on the EB2 I-140. You should give the I-140 approval or receipt. You should include your 485 receipt as well. And if the new, the EB2 I-140 which you're seeking to transfer to your 485, if your EB2 I-140 is still pending, then nothing further is required. But if it is already approved, then you also need to submit a 485 Supplement J form. And all this information should be sent to a new address. So they've given an address: U.S. Department of Homeland Security, USCIS Western Farm Center, 10 Application Way, Montclair, California 91763. So they've given a new address that this information should be sent to. If you've already submitted the transfer request, they're saying that you don't need to submit it again. They're saying that they are looking into it. And they're also saying that if you submitted a 485J form, then they will send a receipt. So if you're not submitting a 485J form, then you will not get a receipt as proof that they have received your interfiling request. But if you do submit a 485J along with your interfiling request, you will get a receipt, and that's proof that they have that they have received your 485 interfiling request. So again, you don't need to submit a new adjustment of status. You can simply interfile your EB2 I-140 with the pending 485. So that's the information, the new announcement that we have. But we can go into further depth, Torni, with reference to what are the eligibility requirements for 485 interfiling.
Please, let's actually, you were wanting to give our viewers a detailed, in-depth interview today, so maybe we should do that, Ms. Reddy. Maybe please tell our viewers about, yeah, please go on.
Okay, thanks. So, again, as I said, this transfer of underlying basis of 485 I-140 interfiling is not a new law. It is already in existence, and there is a lot of information on it, which might be interesting to you, to our viewers, because they'll be able to decide whether they qualify or not, and in certain circumstances, what is the best course to follow. So 485, the interfiling or transfer of underlying basis is applicable in many different scenarios, and not just employment based, in many other scenarios. So we will talk about it in more general terms, and specifically also to employment based. So examples of some instances in which interfiling is allowed is if the applicant has applied for adjustment of status on an employment based petition and later marries a US citizen and now prefers to adjust based on the US citizen filing. they don't have to file a new 485. They can file the I-130 and ask for interfiling at the same time, since an I-130 can be concurrently filed with a 485. Also, an applicant who originally applied for adjustment of status through a spouse can now ask for an interfiling based on employment-based petition. The reason they would do this is if you're filing through a U.S. citizen spouse, you would have to wait for 3 years and then file for a permanent green card. And to avoid that step, some people, if their employment-based petition is current, might prefer to go with the employment-based category. So the reverse is also true. Applicants who applied for adjustment of status employment-based in one preference category could move to another preference category. And this other preference category could be another employer also. It doesn't have to be the same employer. So you filed an I-140 with EB3. Later on, another employer filed for a EB2 I-140 petition for you. You could use the same pending 485 to switch to the other employer who has the EB2 petition filed for you. So remember, you have to show, of course, that you qualify and submit all the required documents, but that's another example of interfiling. Now, an applicant who applied for adjustment of status based on a special immigrant petition could move to a different category, to an employment-based category. For example, under violence against women, that's a special immigrant petition. So if you file under there and you have an employment-based petition also, you could, seek to move it to an employment-based petition. So another way is an applicant who applied for adjustment but wants to file for a diversity visa. Maybe he applied under an employment-based but wants to file under a different category. That's a possibility also. That's a possibility also. So those are some of the examples of where interfiling can be done. Now going to the eligibility requirements. When considering a request for transfer, the officer would look to see whether you are still eligible or not. So there has to be a continuing eligibility to adjust status. So the applicant has to continue to maintain eligibility to transfer. A transfer cannot be granted if there is a break in eligibility. Let me give you an example. Somebody filed a family-based petition, and then in May, say, then in last year, 2021. In June, they filed 485 to adjust. And then in August, the divorce happens. So there's a divorce and the person loses eligibility. And then what happens in September, a month later, the person marries another US citizen, right? Then in October, the applicant's new spouse files a petition for the application based on the new marriage.
Right.
A month later, the applicant appears for adjustment of status for an interview with the divorce decree from the first marriage and a marriage certificate from the new marriage, and requests that the I-130 be transferred, the underlying petition be transferred. In this case, applicant has not maintained continuous eligibility because there was a break. So at the time that the request was made, that is in November 2010, not eligible anymore because the divorce took place in August of that month and there was a break in eligibility. Therefore, the office in such a situation will no longer approve that case and will most probably ask for that person to file a new 485. So that there should be no break in the eligibility. So that's an example for that. So also if the petition, say, was withdrawn, the 485 was withdrawn or the 485 was denied or revoked, then there's a break in eligibility and you cannot then ask for transfer to another case or transfer to another employment-based petition. None of that is possible. Also, if the original adjustment application was based on an I-140 and the USCIS determines that it was fraudulently filed or there was fraud or misrepresentation, then they will also not be eligible for a transfer to another I-140. So that's another thing. Fraud is always will break the eligibility as well. Also, the adjustment of status application cannot be transferred if it's withdrawn. So if the applicant chooses to withdraw the 485 and then changes his mind and then says, okay, I want to transfer to my EB2 now and I don't want to withdraw, you're out of luck. And even if the I-485 was denied and then reopened, even then, you cannot file for a transfer. It has to be still pending. And it cannot also, if the 485 is adjudicated already, then of course, you cannot ask for a transfer to the other I-140. So another eligibility, also the eligibility is that evidence has to be provided for the new immigrant petition in support of the request to transfer. Evidence required can be found on the adjustment application's filing instructions as to what evidence has to be submitted in order to be eligible for the transfer. So first of all, you have to be eligible. Second, you have to submit evidence that you're eligible. And a transfer request is treated as if it were a new filing, and the applicant should provide the information to establish that they're eligible. Like if you're filing a new 485, the information that you would provide on the I-140, that same information has to be provided, and the burden of proof to provide that information is on you, the applicant. In some instances, say you're inadmissible, the USCIS will consider that and see if you're still, eligible for an I-140 transfer. An example of that is, say an applicant applies for adjustment of status as the spouse of a US citizen, and then an employer also petitions for the applicant a month later, and then a month after that, the employer's employment-based petition is approved. So, if you're filing for a spouse-based petition, that eligibility criteria is different. You can be out of status and you can still file a 485. But now if you're asking for that to be transferred to an employment-based petition, then you may not be eligible if you're out of status. So the transfer request will not be approved, right? So eligibility is important. You have to be eligible for the 485 under the new immigrant petition, okay? So another criteria for transfer is visa being immediately available. Now, as per the priority date, as we know, there's a visa bulletin, and you have a priority date based on when your labor was filed. So when you're requesting for the transfer of the I-140 to the pending 485, I-140 that you have should have a date, a priority date, which is immediately available. So your priority date should be current as per, the visa bulletin. So that is important. So say you're in January and you're eligible to file in February, you cannot ask for the transfer in January. You have to wait for February to ask for that transfer. Okay. So even though you know that it's going to be available in February, you cannot request it in January. You have to wait for February. Priority date, of course, you have to remember that priority date can be transferred from one I-140 to another. So make sure you transfer your priority date from the EB3 to the EB2 or request for a transfer, and then check accordingly if your visa number is available. You have to remember one thing, that when choosing between USCIS, if they're going to choose between a US citizen spouse category and employment-based category, they will most probably choose the US citizen spouse category because no visa numbers are required for that. While there are visa numbers required for employment-based, and they want to conserve the employment-based visa number category. So most probably they would opt for, if you have both options, they would opt for an option where visa numbers are not being used up for the general public. So that's something to remember. Exercise of discretion. You have to remember that it's up to the USCIS to decide whether they will consider your request or not. So they look into the reasons for the request, they look into the availability of documentation that you have to support your new claim, the degree of difficulty that they would have in obtaining receipt files from another USCIS office. They need to request for the file from another office, and if they're having difficulty doing that, they may not, approve your request. So again, they are going to look into all these reasons, and they're going to decide whether you're eligible for a transfer or not. Also, you could, a new application fee is not required. Requests have to be made in writing. If you have an already pending I-140 and 485, and you want to file a new I-140, you can file the new I-140 and request that it be transferred to the pending 485. Very important. So even if you don't have an I-140 right now, but if you have a priority date that is current and you want to file the I-140 now, you can do it. And while you're filing the new I-140, you can request, you don't have to file the 485 again. You can request that the old 485 be used. I'm giving you a lot of information in a short period of time, and I hope this information is useful because, it's everything that I'm saying is very important. You can move from one approved I-140 to another approved I-140. You can move from an approved I-140 to a pending I-140. You can move from a pending one to an approved I-140. The reverse is possible. And of course, if you have a pending I-140, you can move to another pending I-140. Now, quickly, with reference to AC-21 portability provisions, if you have requested a transfer, then you cannot change your employer for 6 months. You cannot do AC-21. It's considered as if the clock is reset and as if the 485 was just filed for AC-21 purposes. So wait for 6 months before you can change your employer. Very important again. Derivatives can file for transfer as well, as long as the principal applicant remains, approvable. The principal's application remains approvable, and the principal applicant, remains able to adjust. So his basis for adjustment should not have been somehow compromised. So as long as principal applicant is good, derivative applicant can also request for transfer on their own. Say maybe they've applied for as a derivative, then they can move to their own I-140 as well. That can be done as well. So that's something to remember.
Ms. Reddy, before we end the session, I'd like to say that we really thank you for all the plethora of opportunities. Your information, I'm sure, opens up for all our viewers. And viewers, I hope you're all making notes because of the valuable information she's giving out to us. And like all the time that I say, we're very thankful for the insights that you give us, Ms. Reddy. And with that, we end the show for today. Thank you.
Thank you, Torni.
You're watching Sakshi. This is Torni Makana signing off. Thank you.